Just the jurors. Do we have all the jurors here? I see Juror McGinnis, Juror Eslick, Juror Lipschitz, and that should be it, I believe. I see Mr. Owens and I see Miss Branham. So do we have everybody here that we need to have?
Believe so, Your Honor.
All right, great. I guess first, one little note. I've got my camera here, but I've got my computer with the ballot this way. So if you see me looking to the side, I'm sure you're used to this by now. We've all done plenty of Zoom trials. I just want to let you know I am not ignoring you. I am trying to write and score properly. So with that said, are we ready to go?
Before we begin, Your Honor, can the plaintiff and defense introduce themselves?
Yes, please.
Good afternoon. My name's Clay Owens. I'm joined by my second chair, Michael Lee.
Good afternoon, Your Honor.
Mr. Lee, good to see you.
And together we represent the estate of Jessica Marks.
Permission to introduce ourselves, Your Honor?
Yes, please.
Good afternoon. My name is Abby Branham, and I, alongside my co-counsel, Miss Emily Hinton, represent the defendant in this case, Sonny's Bar in Los Angeles, California.
Okay, great. Anything before opening statements? I'll give it to you, Mr. Owens, first.
Just a few things from us, Your Honor. We just moved to invoke Rules 603 and 615, constructively swearing in and sequestering all non-party witnesses.
Ms. Branham, I assume no objections to that?
No objections, Your Honor, and our party representative today will be Miss Sunny Mehta.
Okay, great.
With that, plaintiff's ready to go.
All right, Ms. Branham, anything else?
Yes, Your Honor. Due to the technology involved in today's trial, we would just ask that if at any point you're having trouble seeing or hearing us, that you just go ahead and interrupt and let us know. Yeah,
of course. And that goes for jurors as well. If there's any technical difficulties on your end, I guess first try the chat function if you're able to do that. But if you're not being seen by me, just say something, and the competitors as well. Just say something, and we'll figure it out. I think we're all used to the potential of technical difficulties, and for lack of a better phrase, stuff happens, and so we'll deal with it if it does. But I appreciate you bringing that up. Anything else?
Yes, Your Honor. One other brief housekeeping matter, just regarding your preferences on the displaying of exhibits in this online format. Would you
do whatever my advice is, do whatever you are comfortable with, that you feel will ease and assist in your advocacy?
Yes, Your Honor. When we do display exhibits for witness identification prior to them being entered into evidence, can we assume that they are constructively outside of the jury's view until they're entered?
Yeah, that's fine. Mr. Owens, are you okay with that?
Absolutely.
Okay, yeah, that's fine with me then.
And with that, Your Honor, the defense is ready to proceed to openings.
Okay, great, let's do it.
Opening for the plaintiff. May it please the court. When they should have saved her, they served her. On March 24th of 2019, Jessica Marks did something a lot of underage college kids do. She drank. When you're 19, it isn't legal, but it happens. But instead of waking up the next morning with a nasty hangover, Jessica didn't wake up at all. Because you'll learn that on March 24th, Jessica brought her best friend, a man named Morgan Levin, to the defendant's bar, a place called Sonny's Rooftop. You'll learn that they ordered some drinks, ordered a few more, and soon enough, they were getting tipsy. But you'll hear when the defendant saw Jessica was drinking too much, they didn't stop her. They gave her drink after drink after drink. And you'll learn that when they knew Jessica needed to be cut off, they let her keep going. That when they should have saved her, they served her. So by the time Jessica left the bar that night, she was stumbling around, slurring her speech. She lost control. You'll hear she got behind the wheel of her car, pulled out on the Pacific Coast Highway, and in seconds was dead at the bottom of a ravine. So why are you here, members of the jury? Well, you see, California has what's called a dram shop law. What that means is if a business serves a minor alcohol when they're clearly intoxicated, they're liable for the damages that happen because of those drinks. And so today, the defendant, Sonny's Rooftop Bar, is being sued for wrongful death. That, of course, means we bear the burden today. We have to prove by a preponderance of the evidence, which is just more likely than not, that the employees of Sonny's Rooftop Bar gave Jessica drinks when she was clearly drunk, and that those drinks helped cause her death. And to meet that burden, we'll only have to call one witness to the stand, Morgan Levin, Jessica's best friend who was with her that night. Mr. Levin will explain how they ended up at Sonny's Bar in the first place. He'll tell you about how those drinks had Jessica out of control. And he'll tell you the defendant was serving Jessica drinks moments before she got behind the wheel. What's worse, by the end of today's trial, you will hear that the defendant admitted they knew Jessica needed to stop drinking, but let her keep going anyways. Because at the end of the day, members of the jury, you'll see this case is about a business that was careless. A company that wasn't worried about protecting a 19-year-old girl. That when they should have saved her, they served her. That's why at the end of this trial, I'll come before you again and ask you to find the defendant liable. Thank you.
Thank you, Mr. Owens. Ms. Brand, whenever you're ready.
Yes, Your Honor. May it please the court, counsel, members of the jury. You can't prevent what you can't predict. You see, we agree with the plaintiff that on March 24th of 2019, employees at Sonny's Bar served somebody who was under the age of 21 alcohol. We agree that on that night, Jessica Marks was intoxicated, and we agree that when she got behind the wheel of a vehicle, that it veered off the road and that she died that night. And members of the jury, that is a tragedy. But our agreement ends where Mr. Owens just got up here and told you that the employees at Sonny's Bar knew about or are responsible for any of that. Because when the plaintiff came into this courtroom today and brought a civil suit of wrongful death against Sonny Mehta and her family, they brought with them a burden to prove that she and all of her employees knew just how intoxicated Jessica Marks was and that their actions led to her death. They won't be able to meet that burden because, members of the jury, you can't prevent what you can't predict. Today, you'll have the opportunity to hear from Miss Sonny Mehta, the owner of Sonny's Bar in Los Angeles, California. She'll take the witness stand and tell you about exactly what she and her other employees knew on March 24th and what they didn't know. Listen carefully as she tells us that she and her other employees had no way of knowing that Jessica Marks was intoxicated that night. Listen as she describes where Miss Marks was sitting on the rooftop of her bar away from the employee's line of vision. Listen as she tells you that every time she and other employees interacted with Miss Marks that she was speaking coherently, that she didn't seem intoxicated at all. Next, Ms. Mehta will testify that there was no way she or the other employees could have known just how much Jessica Marks was actually drinking. Today, you'll hear testimony from a bar patron who was at Sonny's Bar on March 24th, who was sharing alcohol with Jessica Marks that day, patrons who weren't employed by Sonny's Bar, who Ms. Mehta had absolutely no control over. Finally, listen as she testifies that when Jessica Marks chose to get behind the wheel of a vehicle that day, that she had absolutely no idea about that. and that if she had known, she certainly would have done everything in her power to stop it. Throughout the course of this trial, it's important to remember that it's the plaintiff who has the burden of proof here. Even though we'll present evidence to you as the defense here, it's not our job to prove anything. It'll be Mr. Owens' job to prove by the greater weight of the evidence that the employees at Sonny's Bar knew just how much Jessica Marks was drinking and that it was their actions that caused her death. When he can't do that, when he's not able to meet that burden of proof, I'll come back up here before you and ask that you come to the only verdict that the law and justice will require. A verdict of not liable because you can't prevent what you can't predict. Thank you.
Thank you, Ms. Branham. With opening statements concluded, are we ready for the first direct examination?
Yes, Your Honor, plaintiff's ready.
Great. I think I'm supposed to make a note, gallery view, hide non-video participants, yada, yada. If anybody doesn't know how to do that, speak now and we can walk through it. Sounds like everybody's good, so let's go.
Plaintiff calls Morgan Levin. Can you introduce yourself to the members of the jury?
Hi, everyone. I'm Morgan Levin.
Do you know why you're here today?
I do. I'm here to talk about what happened to my best friend, Jessica, on March 24th, 2019.
I want to take a step back. How long have you known Jessica?
Since we were little, we were best friends in like middle school and high school, and we've done everything together since then.
When was the last time you saw her?
2019 on spring break. She visited me at UCLA. That's where I go to school. And that was the last time that I saw her.
So I want to talk about that date you mentioned earlier, March 24th of 2019. Were you with Jessica that day?
I was. We had sort of hung out during the day and we went to Sonny's rooftop bar that night.
Do you remember when you got to Sonny's?
I do. I think it was about 9 o'clock that night.
Mr. Lee, can we get that on a timeline, please? So what did you do once you got to Sonny's bar?
Nothing too out of the ordinary. We sat at a table. We just kind of talked about the day, about the trip. And we ordered some drinks and just sort of talked.
Did you happen to take any pictures of those drinks you were served?
I did. Yeah, I took some pictures of the table as the night went on.
Would you recognize some of those pictures here in court today?
I think so, yes.
Can we get exhibits 12, 14, and 16 on the screen? Mr. Levin, are these those pictures you took?
Yeah, these are some of the pictures that I took.
Have they been changed or altered since you last saw them?
No?
Plaintiff offers exhibits 12, 14, and 16.
Any objection?
Without objection.
They're admitted.
So let's talk about some of these pictures, starting with exhibit 12 there. Do you happen to remember when you took that picture?
The first picture, exhibit 12, I think I took this one at 9:16.
Can we get that on the timeline? And at that point, when your table looked like that, did Jessica look drunk to you?
Not really. I mean,
Objection, Your Honor, calls for speculation. May I be heard?
You can explain, yeah.
Yes, Your Honor. The characterization of whether or not Jessica Marks looked drunk that evening is an improper one. It's speculative by nature. Being drunk is a mindset. That's something only Miss Marks would know. This witness is certainly able to testify to his observations of Miss Marks that evening, but to quantify that as drunk or not, that's improper, Your Honor.
Mr. Owens?
Yes, Your Honor. As we all know, when someone's drunk, there are a lot of visible signals that they're like that. And there's a lot of auditory signals as well. If someone's slurring their speech, stumbling around, those are all things that common sense tells us you associate with being drunk. So certainly it's not speculative to ask this witness, who was Jessica's best friend, if she looked drunk, if she was exhibiting any of those classic symptoms. That's not speculative.
Mayor,
Your objection, your last word, Ms. Branham.
Yes, Your Honor. Again, we don't have any objection to this witness testifying to his observations of Jessica Marks. If he wants to talk about the observations he had about her physical condition, we believe that that is absolutely able to go on the record today. But for him to quantify that as whether or not she was drunk, especially when one of the elements in contention today was whether or not she was obviously intoxicated, that's a distinction for the jury to make and not for this witness to make.
Ms. Branham, do you dispute that she was intoxicated?
Your Honor, it's just the speculative nature of how that question is phrased is what my objection is to.
I understand, but I'm asking you a question. Are you disputing that she was intoxicated at all?
Your Honor, our dispute is about the obvious intoxication, which is an element contested in this trial. So whether or not she was obviously intoxicated is certainly relevant. That's a distinction for the jury to make.
So I'm going to ask a third time. Do you dispute that she was intoxicated?
No, Your Honor, we agree that she had drinks that evening.
Okay. Well, having drinks is different than intoxicated. So
Yes.
I'm just trying to clarify your position here. So you do not dispute that she was intoxicated.
Correct, Your Honor.
Okay. I take your argument, Ms. Branham. I think it's close, but I think Mr. Owens is right. I think being drunk is something that a lay witness can properly attest to. If you feel that Ms. Branham, if you feel that the witness has issues with providing that type of testimony, if you think there's a reason that the jury shouldn't credit his belief, you're more than welcome to address that on cross-examination. So I take your point, Ms. Branham, but the objections are.
Yes, Your Honor.
So, Mr. Levering, you were telling us if Jessica looked drunk to you. Were you finished?
At that point, no. During when the first photo was taken, those were the first few drinks they'd given us, and at that point, no. I think it was a little bit later on in the night that she started, looking like she normally does when she's drunk.
What happened?
Well, I mean, we'd had a little bit more to drink, and she was, slurring her words. Her eyes sort of started getting red. She started like having problems with her balance. She actually fell down at one point when we went in to go to the bathroom.
What happened when Jessica fell down?
So we were coming down the stairs to go to the bathroom, and she kind of like stumbled and caught herself on one of the bartenders. I think it was Sonny Meda. He was the owner. And that's sort of what happened.
When Jessica fell into Miss Maida, did she say anything?
So Miss Maida said that they needed to cut this one off. She said, I think we need to cut this one off. She said that to the other bartender.
And do you remember when that was?
I do. That was around 10 o'clock.
Mr. Lee, can we get that on the timeline? So after Sonny said, we might need to cut this one off, did she keep serving drinks to Jessica?
Yeah, I mean, we went to the bathroom, we went back outside, and it was like nothing even happened.
Can we get exhibit 14 on the screen? Does this picture show any more drinks from after that point?
Yes, this is later in the night. I took this one about 10:18, I think.
And can we get that on the timeline, 10:18? So from what you saw, did Jessica's condition get any better?
No, she started slurring her words a lot more. I took a video of it. She was slurring her words a lot.
Can we get exhibit 10? Is this that video that you took?
It is, yeah, this is the front of it.
From what you can tell, does it appear to be changed or altered since when you took it?
Not from what I can see here, no.
Plaintiff offers exhibit 10.
Any objection?
Without objection.
It's admitted.
Can we play that?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Mr. Levin, when did you take that video?
Around 11 o'clock.
Can we get that on the timeline? So did Sonny say anything about Jessica's condition after you took that video?
Yeah, I mean, Sonny looked at me and pointed at Jessica and said, I hope this one's not going to be driving tonight.
And did you get even more drinks after that?
Yeah, we kept ordering them and they kept bringing them to us.
Let's get Exhibit 16. Is this a picture of those extra drinks?
Yes, these are the drinks we ordered later.
Do you remember when?
I took the picture at 11:32. I don't remember exactly when the drinks got ordered.
And can we get that on the timeline, 11:32? So did you see Jessica drive away that night?
I did. Around 11:45, we were leaving, and I didn't want to get in the car with her, so I called an Uber, and she got in the car. I wish that I'd stopped her. I wish that I had done something to said anything, but I let her drive away.
After Jessica had all those drinks at the bar, what happened when she got behind the wheel?
I mean, she turned onto the highway. She just like started driving, and it wasn't very long. She just drove right onto the other side of the divide and just went off into a ravine.
Do you know if your friend made it out?
She didn't. She didn't make it.
Thank you for your time, Mr. Levin. Your Honor, I have nothing further.
Thank you, Mr. Owens. Ms. Branham, cross-examination.
Yes, Your Honor, may I proceed?
Whenever you're ready.
Mr. Levin, you just talked about what you say happened on March 24th, but I want to talk about something you didn't mention before, okay?
Sure.
The plaintiff in this case threatened to sue you for Jessica Marks's death.
That's right. Miss Marks was really upset after Jessica died, and she told me she was thinking about suing me.
You were originally supposed to be the defendant in this case, right?
I'm sorry?
So you were originally going to be the defendant in this case.
No, I mean, she never sued me. Like she never filed a lawsuit against me. No.
But yes or no, she threatened to.
That's right. She did right after Jessica died.
But now you're testifying for the plaintiff, right?
Yes, ma'am.
Well, let's talk about what happened in between. You spoke to the plaintiff's attorneys before you testified today.
I did. Yeah, just for a couple minutes.
You spoke to them before you were deposed for this case.
That's correct. Yes.
Now you admit that your memory of March 24th, it isn't perfect.
No, it was 2 years ago. I remember some of what happened, not everything.
Right, this took place 2 years ago.
Yes.
You had been drinking that night.
Yes, I had a few drinks.
You'd agree that you were somewhat intoxicated.
A little bit. I think I had 3 drinks that night.
But sir, you just gave a pretty detailed account of what happened that night, didn't you?
Yeah, I mean, my best friend died. I remember what happened.
Well, you have that detailed account after you spoke to the plaintiff's attorneys for hours, right?
I'm sorry?
That detailed account you just testified to, you're testifying now after you weren't named as the defendant in this case.
Yes.
I want to talk about some things you didn't mention before. When you and Jessica were at Sonny's bar in Los Angeles on the 24th, you interacted with some of the employees.
We did, yeah. We talked to Sonny, and I think that Jessica talked to the other bartender too.
And those interactions, they weren't long conversations, right?
No, I mean, it was just small talk. They were taking our order, just sort of chatting with us, and then they would leave.
Sure, they'd come over to your table, they'd take an order,
Yeah.
they'd drop off food or drinks.
Yes, ma'am.
But those interactions, they didn't take place for more than 30 seconds to a minute, right?
Yeah, that sounds right to me. I mean, 30 seconds to a minute sounds right.
And now, sir, during those interactions, you certainly never told those employees that Jessica had driven to the bar that night.
No, I didn't tell them that.
You didn't watch her tell that to employees.
No, when I was there, she didn't say that.
So for all you know, those employees had no idea that her car was in the parking lot.
I don't know.
But sir, you knew that, right?
Yes,
And you chose not to get into her car that night.
I did. She was drunk.
You chose to get into an Uber instead, right?
Yes, I wish I had pulled her in there with me. Yes,
That's right, you begged Jessica to get into that Uber with you.
I tried.
But she didn't do that, did she?
No,
Instead, she chose to get behind the wheel that night, right?
yeah, she got into her car.
Thank you, Mr. Levin. I have nothing further at this time.
Thank you, Ms. Branham. Any redirect, Mr. Owens?
None, Your Honor. May Mr. Levin be excused?
Yep. Thank you, Mr. Levin, for your testimony.
At this point, the plaintiff rests.
Okay. Ms. Branham, do you have a witness?
Yes, Your Honor. At this time, the defense calls Sonny Mehta to the stand.
Okay. I'm ready when you are, Ms. Branham. So, Mr. Owens, you set?
Sorry, a bit of a malfunction over here with the stand from my laptop was on. My apologies.
No worries, no worries. All right. You good now, Mr. Owens?
Yes, Your Honor. Sorry about
All right.
that.
Now, whenever you're ready, Ms. Branham.
Yes, Your Honor. Please introduce yourself to us.
Good afternoon. My name is Sonny Mehta.
Ms. Mehta, what do you do for a living?
Essentially, I run a bunch of businesses, mostly bars and restaurants, though, that type of thing, hospitality.
I want to go ahead and draw your attention to a specific bar that you owned back in March of 2019. Did you own a Sonny's Rooftop Bar at that time?
Yes, as the name indicates, I bought the bar and named it after myself.
Ma'am, I want to go ahead and draw your attention to the reason we're in court today. I want to talk about one night in particular, March 24th of 2019. Were you at your bar that evening?
I owned the bar, but it was a Sunday, it was slow, so I was helping to serve tables that night.
Do you remember if anybody else was working with you that night?
Yes, I have a small staff, normally, no more than 10 people. That night was just me and my bartender, though, Frankfurt.
Ms. Mehta, do you remember if a girl named Jessica Marks ever came into your bar that evening?
She did. Miss Marks came in at around 9 o'clock, I think, with her friend, someone named Morgan Levin.
I want to go ahead and talk now about your observations of Miss Marks and her friend that night. When they first came into your bar, did they look to you to be intoxicated?
No, not at all.
What were your observations of them when they walked in?
I mean, they just seemed like they were regular customers, nothing out of the ordinary.
Did you serve them that night? Did you wait their table?
I did. I waited all the tables that night because it was just us two employees. So my bartender was stationed at the bar and I was serving tables.
Ms. Mehta, did you know that Jessica and Mr. Levin weren't 21 years old when you served them that night?
Absolutely not. I never
Objection, Your
served.
Honor. To relevance, if I may be heard.
Yeah, you can explain.
Yes, Your Honor. In the jury instructions for today's trial, it's been made clear that whether or not the business knew Jessica and Morgan were 21 has no bearing on the jury's decision.
Is there a specific document in the pretrial materials that you're referencing?
Yes, Your Honor. If you can give me just a moment, I can pull that up for you.
Okay.
Just one moment. Okay. If I can share my screen, I can show you. One moment. All right. It's right here in number 11. On this element, the plaintiff must prove only that Jessica Marks was a minor on the date in question. To be liable, the defendant need not have known that Miss Marks was a minor.
Ms. Branham, what's your response?
Yes, Your Honor. In today's case, the defense has raised an affirmative defense of comparative negligence. The decision of Ms. Marks and Mr. Levin to go to a bar, use fake IDs to consume alcohol under the age of 21, those are all decisions that they made and that contributed, it's our position today, that contributed to Ms. Marks's death. So while it may not be relevant to that essential element the plaintiff has to prove, and while we've already stipulated that she was under 21 while she drank that evening, Your Honor, it still is relevant to our affirmative defense in this case.
Okay.
Response to that?
Yeah, go ahead.
Your Honor, whether or not Ms. Mehta knew that Jessica Marks was under 21 that day, or whether or not Jessica Marks used a fake ID, has no bearing on whether or not her decisions led her into a ditch. What's important is how much Jessica drank. Whether or not she did that against the law or not doesn't make it more likely that that caused her death.
But doesn't, Mr. Owens, doesn't the act of a minor going into a bar and choosing to drink directly relate to her decisions and her actions on that night, which tie into the comparative fault analysis that the jury has to take?
I don't believe so, Your Honor, if I can explain.
Yeah,
The comparative fault claim in today's case that opposing counsel has raised as an affirmative defense is as to who is at fault for Jessica specifically dying, specifically how she ended up in a ditch. Whether or not Jessica was 45 or 19, the fact that she was in that bar and drinking is what matters. Your Honor, it doesn't matter if she was less than 21 when she was in there. That doesn't make it more likely that she was going to die.
Ms. Branham?
Yes, Your Honor, the choices that Ms. Marks made on that day absolutely are related to what ultimately happened, unfortunately, to her on March 24th. We can't take these things in isolation. It is certainly relevant whether or not she chose to go into a bar as a minor under the age of 21 and consume alcohol. That certainly has to do with how she ultimately died on March 24th.
Yeah, I'm inclined to agree with Ms. Branham here. I think, Mr. Owens, I think you're trying to narrowly constrict the relevance, the scope of relevance. And just for the record, I think there is potentially a 403 analysis, but I would rule against keeping it out on 403 grounds as well, because I think Ms. Branham is right that even if it doesn't go to that specific element, I think it is relevant to the affirmative defense, and so I'm going to allow it. So Mr. Owens' objection is overruled, and Ms. Branham, you can continue your questioning.
Yes, Your Honor.
Ms. Mehta, you were talking about whether or not you knew that Jessica Marks and Mr. Levin were under 21 when you served them. Were you able to finish your answer?
No, but at the end of the day, if I know that you're under 21, you don't drink at my bar. That's essentially, I would never have served them if I'd known.
Ma'am, when you did serve them that night, how many times do you remember interacting with them?
I mean, a handful. I was serving other tables that night, so I had other things going on, but I definitely took their orders. I bought drinks to the table.
And how long would you say your interactions with Miss Marks and her friend were?
Very short, no, long conversations.
Would you say you were watching them the entire night?
I wasn't. They were a table that I was serving them, but the bar's downstairs. I go back and forth. I had other tables to worry about, phones to answer, that sort of thing.
Ms. Mehta, were you in court today when Mr. Levin testified about Jessica stumbling that night?
Yes, I was.
Did that happen?
No, in fact, I remember that it was Mr. Levin who was stumbling down the stairs. And when I'd asked if one of them was driving, I was referring to Mr. Levin, not Miss Marks.
You said that you served Miss Marks drinks that night. Do you know if she ever accepted drinks from other patrons at your bar?
I would have no idea.
Your Honor, at this time, permission to read onto the record a statement from another patron at Sonny's bar that night that falls under Rule 804A, a statement from a witness unavailable to testify pursuant to evidentiary ruling number 12.
Who's the witness?
It's someone by the name of Kendall Reutman, Your Honor.
Okay, and you said this issue, there was a pretrial ruling. Can you direct me?
Yes, Your Honor, it's evidentiary ruling number 12.
Okay. All right, so Mr. Owens, I assume that you agree that Kendall Reutman is unavailable pursuant to that evidentiary ruling. Do you have any objection to Ms. Branham's request to read such testimony onto the record?
Your Honor, no objections to hearsay. I only ask that I can see or hear which portion they're actually reading, so I know if it might be objectionable on other grounds besides hearsay.
Sure. Yeah, I think that's fair.
Yes, Your Honor, if I can go ahead and have my co-counsel, Ms. Hinton, go ahead and just screen share that portion of the deposition. It'll just be the highlighted portions.
Okay.
No objections to that, Your Honor.
All right. Ms. Branham, go ahead and continue your
Yes.
question.
Yes, Your Honor. To go ahead and read it for purposes of the record. Did you see Jessica take any shots? Oh, right, I forgot. We took a shot together. Well, not Stevie, me, Jessica, and the person she was with. Who bought them? I think we bought them. I don't know, it was so long ago. Thank you, Ms. Hinton. We can go ahead and take that down. Ms. Mehta, I want to go ahead and fast forward to when Jessica and Mr. Levin left your bar that night. Did you see them leave?
Yes, I saw them head toward the door near the end of the evening.
Around what time was that?
It was probably around 11:45, 11:50.
Did you ever see Miss Marks get behind the wheel of a car?
No, I didn't. I didn't see them in the parking lot at all.
And at any point throughout the course of that evening, did you ever cut Jessica Marks off?
I didn't. She didn't seem, intoxicated enough for me to do so.
You mentioned she didn't seem intoxicated enough. How do you determine when to stop serving someone, if ever?
Because we have a liquor license, I take a certification training annually, which teaches me and my employees how to determine whether or not a person is so drunk that we're required to stop serving them. But on a personal note, I don't serve people who I don't think are okay to continue to have more alcohol. And what happened to Miss Marks, I never could have predicted that.
Thank you, Ms. Mehta. I have nothing further at this time, Your Honor.
Thank you, Ms. Branham. Mr. Owens, cross-examination.
Yes, Your Honor, may I proceed? Good afternoon, Ms. Mehta. I have a couple questions about your bar, okay?
Sure.
Like you said, back in 2019, you owned Sonny's Rooftop Bar.
Yes, at that point, I'd owned it for about 6 years.
On top of being the owner, like you mentioned earlier, you were also a server. You would serve tables.
Occasionally, it wasn't my main job. I mostly ran the business, but occasionally when we were short-staffed, yes.
Well, specifically on March 24th, when Jessica and Morgan came into your bar, you served them.
I did.
They were ordering their drinks through you,
Yes, I was the only server that night.
and you were the one bringing those drinks to their table.
Yes.
So you'd actually recognize the receipt that you gave them at the end of the night, wouldn't you?
Oh, yes, I would.
Can we get Exhibit 17 on the screen? This is a copy of that receipt, right?
Yes, it looks like it.
It's fair and accurate.
Oh, yeah. Hmm.
And of course, as a bar owner, you give receipts to your customers when they buy drinks from you.
That's typically how it goes, yes.
Plaintiff offers Exhibit 17.
Any objection?
Without objection.
It's admitted.
So, Ms. Mehta, you can tell us that on the night of March 24th, Morgan and Jessica, they ordered beers, right?
Yes, 2 of them.
They ordered 3 White Claws.
Yes.
They ordered an entire bottle of red wine.
Yes, a standard sized bottle of wine.
And they ordered 2 of those green tea shot specials, right?
Yes, that's what's on the receipt.
And those shots, they actually have 2 different forms of hard liquor in them, right?
That's right, whiskey and peach schnapps.
Now, of course, you might not know exactly who drank what, but you can tell us that you saw Jessica drinking some of the stuff that was purchased here.
Yes, they were both sitting at the table.
And like you mentioned earlier, you actually interacted with Jessica a few times throughout the night.
Yes, they were there for about 3 hours, so I went up to the table several times.
You would say specifically you interacted with them about 8 to 10 times, wouldn't you say?
Sure, I don't remember an exact number. It was about 2 years ago, but that sounds around correct.
8 to 10 sounds fair, right?
Yeah, it does.
When you were waiting their table, you'd go up to them and ask them what they wanted to drink.
Yes, or eat. They also had food and water at the table.
And sure, they'd talk back to you and give you their order.
Yes, that's generally how it works.
And you're telling us in none of those interactions, did you think Jessica Marks was clearly intoxicated?
I mean, she'd been drinking that night, but no, I was not concerned about her safety.
You got a chance to see what Jessica Marks looks like, right?
When I met her, are you talking about something else? I'm sorry.
Well, specifically, ma'am, you'd say based on what you saw, you'd wager Jessica was only about 5 feet tall.
Yes, she was pretty short.
And after seeing her drink some of those things she ordered that night, you didn't think that 5 foot tall woman was clearly intoxicated?
No, sir, everyone metabolizes alcohol differently.
Sorry, Miss Branham, were you trying to object there?
Yes, Your Honor, it looks like I was muted. I was going to object to argumentative to that form of that question.
Okay, are you going to stand? Are you going to, we can pretend that it happened if you stand, or if you want to make the objection.
Yes, Your Honor, I would just object to argumentative the way that question was phrased, that she really didn't think she was intoxicated that evening.
I don't think it's necessarily too argumentative, but just Mr. Owens, try to not be antagonistic of the witness.
I'm trying my best, Your Honor. I apologize.
We're all trying our best. So the objection is overruled, but keep trying your best, Mr. Owens.
I will, Your Honor. Now, Miss Mehta, you keep telling us you didn't think Jessica was clearly intoxicated, but you know it's your job to stop serving someone if they are.
Yes, if I think they've had too much, yes.
And you know there are certain factors that you're supposed to look for to see if someone is clearly intoxicated. Isn't that true?
Yeah, physical symptoms of intoxication, I'm trained to recognize them.
Well, I'm going to run through a list of some of those symptoms. You tell me if you think Jessica exhibited them or not, okay?
Okay.
Did you see any bloodshot eyes?
No.
Did you see Jessica stumbling?
No, just Mr. Levin.
Did you hear her slurring her speech?
No more than anyone who's had 1 or 2 glasses of wine, no.
Did you hear her start spouting nonsense that didn't make any sense to you?
No, sir, I didn't.
You were actually shown a video of Miss Marks during your deposition, right?
Yes, sir, long after the night in question.
Can we get Exhibit 10? This is that video, right?
Yes.
Can we play that, Mr. Lee?
Hi everyone, Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, Well, go big or go home.
Miss Meta, that video's of the same girl you didn't think was clearly intoxicated that night.
Yes, sir, but I didn't see that video until about 16 months after she'd left my bar.
But you heard today it was posted on Instagram that same night.
Sure, but I didn't see the video then, and I didn't see her acting like that in front of me.
And you'd agree with me, though, that that video shows the same girl you didn't think was drunk.
Yes, sir, it's Miss Marks, but she wasn't acting like that when she interacted with me.
All right, Miss Meta, nothing further.
Any redirect, Ms. Brown?
No, Your Honor. We just ask that Ms. Meta be allowed to step down at this time.
Okay, thank you, Ms. Meta. I understand there are no more witnesses from the defense. Is that correct?
Yes, Your Honor.
All right. Does the defense rest?
We do.
All right. Do we need a couple minutes before closing arguments?
Plaintiff's ready, Your Honor, but if you'd like to take a break, we're more than happy to do that too.
I don't need a break, Ms. Branham. What about you?
Defense is ready to proceed as well.
All right. Well, then if everybody's ready, let's go.
May it please the court. When they should have saved her, they served her. Now, members of the jury, when you just think about how Jessica's car ended up in that ravine, it might not sound all that crazy. Drunk driving accidents are something that unfortunately happen all the time. But when you take a step back, when you start thinking about how Jessica ended up behind that wheel, things start to make sense. You see a business that was careless, a company that wasn't worried about the safety of a 19-year-old girl. With each glass of wine, with each beer, with each shot, when they should have saved her, they served her. And that's why the defendant's been sued for wrongful death. And of course, with that accusation, we as the plaintiff took on a burden of proof. We had to prove our case to you by a preponderance of the evidence. All that means is if you think it's just more likely than not that the members of Sonny's bar were giving Jessica alcohol when she was clearly drunk, and that those drinks helped lead to her death, then you have to find them liable. And to see how we met that burden, I want to walk through the reasons the defendant knew to cut Jessica off. Because first and foremost, you heard Jessica had a laundry list of drinks that night, and we have the receipts to prove it. You saw that Jessica was drinking glasses of wine, chugging White Claw, even taking shots. Members of the jury, you don't have to be a toxicologist to know that just drinking half the stuff on this receipt is going to get you drunk. But members of the jury, the defendant didn't have to read off of a list to know that they were making a mistake because you heard they could see Jessica's table in real time. Because you learned, when Jessica's table looked like this, Sonny Mehta already thought she should stop drinking. Because you learned that an hour after getting into the bar that day, Sonny leaned over to the bartender and said, "We need to cut her off." But it only took her 15 minutes to change her mind and bring Jessica another round. And of course, they weren't going to stop there. Because at the end of the day, members of the jury, you learned that an hour later, they brought another round of drinks to Jessica's table. So when Miss Branham stands up here and she says, you can't prevent what you can't predict, I want you to think about that. How many drinks does Miss Mehta have to serve to Jessica before she's concerned? 5, 10, 20? Members of the jury, there's enough alcohol in these pictures to get an entire group of people buzzed, let alone a 19-year-old girl drunk. But it isn't just a numbers game. Because Morgan Levin took the stand today and relived exactly what happened to his best friend. He told you she was out of control. She was stumbling around, falling down the stairs, dropping her can. With each thing that Jessica did, it was a sign that she was out of control. Members of the jury, Whether it was her bloodshot eyes or her broken speech, there was no excuse for Sonny to serve another drop of alcohol to that young woman. But as Judge Holstead will instruct you in just a moment, members of the jury, no matter how many symptoms I list out for you, the best way to tell if someone is drunk is by using your common sense. So just watch.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Members of the jury, common sense tells you that that's a woman who's had too much to drink. Common sense tells you that that girl is not safe to get behind the wheel, and the law tells you that you can't put another drink in that girl's hands. You stop serving. And what did they think was going to happen? Because you heard that at the bar that night, Sonny said to Jessica, "I hope you're not driving," but then sat and did nothing as Jessica walked out of that door and climbed into her car. And members of the jury, she was only on that road for a couple seconds before she was falling into a ravine to her death. There was no rain, no snow, no ice, just a 19-year-old girl who had too much to drink. Because when Jessica got behind that wheel, there was no barrier, no brake, no prayer that could save her. The only person that could save her was sitting behind her bar pretending it was business as usual. At the end of the day, members of the jury, it was never about the law for the defendant. It was never about safety. Because you heard, Sonny had every opportunity to stop Jessica from drinking. Every beverage brought to her table was another chance to say no. Every sip was another chance to cut her off. But members of the jury, when the defendant should have saved her, they served her. And now a young girl's dead. Find the defendant liable. Thank you.
Thank you, Mr. Owens. Ms. Branham, whenever you're ready.
Yes, Your Honor. May it please the court, counsel, members of the jury. Before I go any further, before I talk about the evidence that's been presented today, before I address the burden that the plaintiff has here, the first thing I want you to hear from us as the defense is that what happened on March 24th was an absolute tragedy. What Jessica Marks's family had to go through, the death of a child, that's not something that any family should ever have to deal with. But today, when the plaintiff came into this courtroom and accused Sonny Mehta and her family of being responsible for that death, that's a weighty accusation to make. And the law, it's clear about what their burden is because of that. Because when the plaintiff came into this courtroom today and they accused Sonny's bar of wrongful death, they brought with them a burden to prove every element of that charge to you by the greater weight of the evidence. So let's take a look at the elements they committed to proving to you today. Let's start with this first one. Jessica Marks was under the age of 21 on March 24th of 2019. Members of the jury, we've agreed from the beginning of this trial that on March 24th, Jessica Marks was only 19 years old. So really, this trial, your decision today, it's going to come down to these final two elements. Number one, that the people and the employees at Sonny's bar knew they were serving alcohol to somebody obviously intoxicated, and that their actions, the employees at Sonny's bar, were a substantial factor in Jessica Marks's death. Really, what those elements come down to, members of the jury, is knowledge. Whether or not the employees at Sonny's bar that evening knew that Jessica Marks was intoxicated, and whether or not the drinks they served her are the reason she's no longer with us. So let's talk about that. Let's talk about what the evidence has shown they knew today. Starting with this first point. Did the evidence really show that the employees at Sonny's bar actually knew Jessica Marks was intoxicated? Because we heard today that the only two employees at that bar were Miss Mehta and the bartender that she had employed there as well. We heard that they were at the bottom of that bar with Jessica and Mr. Levin sitting at the rooftop. Let's go ahead and talk about the testimony of Mr. Levin, because it's the only thing we have on the record here that shows that the physical symptoms of Jessica Marks were anything other than coherent. Members of the jury, when you go into the jury deliberation room, the judge is going to tell you that part of your job today is to weigh the credibility of witness testimony. When you're doing that, I want you to think about what Mr. Levin's testimony was today. Before this trial even began, he was threatened with this lawsuit. He was facing the reality that he might be the one in the defendant's chair here. And it was only after speaking to the plaintiff's attorneys for hours that he was able to fill in the gaps in his story, the gaps in his memory from a night where he was drinking, a night that took place over 2 years ago. And now he's in here testifying about specific elements of the plaintiff's charge. So if we take away that testimony, if we think that maybe it's not so credible, the only thing that the evidence has shown the employees of Sonny's bar knew was that they had a few interactions with Miss Marks for 30 seconds to a minute at most. That there was no way to tell that she was intoxicated. You heard that Miss Mehta didn't see Miss Marks acting the way she was in the video that was taken that night. Next, let's talk about how the evidence has shown the employees at Sonny's bar didn't know how much Miss Marks was really drinking that night. We saw a receipt of a tab summary from that evening, but members of the jury, we don't know who drank what on that receipt. At the end of the day, Miss Mehta and her employees, they're bartenders, they're not babysitters. It wasn't their job to sit by Miss Marks all evening and police what she was drinking. They brought drinks to a table. They had no idea if they were just for Miss Marks or for her and Mr. Levin. They had no idea if they were being given to other tables. We heard evidence today that other bar patrons were giving Miss Marks drinks that night. So when we're talking about how much she was actually drinking, there was no way for Miss Mehta to know that. Finally, when we're talking about the decision that Miss Marks made that day, the decision to get behind the wheel of a vehicle, we know that they didn't have knowledge of that. You heard that Mr. Levin chose to take an Uber home that evening for all Miss Mehta knew. When Miss Marks was walking out of the bar that night, she was walking out to another car with a different driver, just like Mr. Levin did. We haven't heard testimony that Miss Mehta saw her get behind the wheel at all. You know who would have known all of these things? Who would have known the level of her intoxication, how much she was actually drinking, that she would get behind the wheel? That's Jessica Marks. And members of the jury, I understand that it may sound insensitive for me to stand here and say that Miss Marks had anything to do with what happened on March 24th, but we've got to face the reality here. That 19-year-old Jessica chose to get behind the wheel of a vehicle after drinking alcohol that night. A decision that she made that day, a decision that Mr. Levin chose not to make, a decision that he begged Miss Marks not to make that day. Every single day, when people make the decision to drink and drive, we hold them responsible, because they're not just putting their own life at risk, they're putting the lives of all of the other drivers and passengers around them at risk too. So when Jessica Marks chose to take her car keys and stick them in the ignition that day, she made a decision. And when you make your decision in this case, when you're deciding what your verdict is going to be, the judge is going to tell you part of that is deciding who is to blame here. And as insensitive as it may sound, to say that Miss Marks has any blame for what happened, we've got to face the reality that she made decisions that night. She made decisions to go to a bar and drink underage. She made decisions to take drinks from other patrons of that bar. We don't even know what were in those drinks. And she chose to get behind the wheel of a moving vehicle. Members of the jury, what happened to Jessica Marks? What happened on March 24th? That is an undeniable tragedy. But to assign blame for that death to another family, to assign blame where it doesn't belong, that only multiplies the hurt here. That's why I ask that you do the only thing that the law and justice allows here. I ask that you find the defendant not liable. Thank you.
Thank you, Ms. Branham. Mr. Owens, do you get a rebuttal?
Yes, Your Honor. I believe I have about 2 minutes left.
Okay, great, go ahead.
Members of the jury, I want you to just stop and think for a moment about exactly what Miss Branham is asking you to believe. Because on one hand, she tells you to disregard all of Mr. Levin's testimony because there was a chance he could be a civil defendant, and then turned around and told you to trust her client, a civil defendant. Because at the end of the day, members of the jury, we actually know that Morgan's story is corroborated. We have videos, we have pictures that show that Jessica was out of control. And the only person who ever said once in today's trial that Jessica wasn't clearly intoxicated is the same person hiding behind a wall of excuses, Miss Mehta. Because members of the jury, no matter how much Miss Branham says, there was no way Miss Mehta could have known that Jessica was drunk. You heard that she was bringing Jessica drinks 8 to 10 times. You don't think in all those interactions, with each time she walked up and sat a drink on that table, she could tell that that girl was out of control? Members of the jury, it wasn't that Miss Mehta couldn't predict it. It's that she chose to ignore it. Find them liable. Thank you.
All right, thank you, Mr. Owens.